I'm here falsely accused for a 21-year-old warrant. And I tried to speak, and she acts like Judge Judy. She just constantly cuts you off, is threatening. And if you look at the TV show Judge Judy, this is how she acts, Judge. And I'm just being treated like I'm just a criminal. I'm supposed to be innocent until proven guilty, right? And I would like an investigation as to things that's been going on by the prosecutor's office, because Kim Worthy and her subordinates are retaliating against me. There's actual proof. But she has an attitude like Judge Judy. She just cuts you off. And I'm just like, so when she kept doing it, this is when I objected and asked her to.
Today's hearing centers on one of the most baffling sovereign citizen cases we've covered yet. This defendant is back in court following a prior preliminary hearing with Judge Martin, but instead of focusing on the charges, he went AILN. On the usual sovereign citizen rhetoric, from the start. He cast himself as the victim, even going so far as to request Judge Martin's recusal, claiming she behaved like a TV courtroom judge and kept cutting him off. In reality, she was simply trying to keep the proceeding on track while he ran through a memorized script of pseudo-legal jargon. It's the kind of performance you have to see to believe. Let's break down exactly what happened and why this approach almost guaranteed things wouldn't go his way.
Colonel Michael McCreary appearing in appropriate persona.
All right. It's my understanding, sir, you filed a motion to have Judge Bryant disqualified from the case. Judge Bryant denied your motion, and essentially your motion was appealed up to the chief judge, which is me. Is that correct, sir?
That's correct.
Okay. Argument.
Well, the argument is, sir, under Michigan Code of Judicial Conduct, the judge is in violation of Canon 1 and 2 because I'm here falsely accused for a 21-year-old warrant. And I tried to speak, and she acts like Judge Judy. She just constantly cuts you off, is threatening, so far as be quiet. Like, I mean, Canon 2, it says public confidence in the judiciary is eroded by irresponsible or improper conduct by judges. A judge must avoid all impropriety and appearance of impropriety. A judge must expect to be the subject of constant public scrutiny. A judge must therefore accept restrictions on conduct that might be viewed as burdensome by the ordinary citizen and should do so freely and willingly, Judge. And I come into court very respectful. I'm a 51-year-old man and I respect the system. But I'm feeling that I'm being given, disrespect. I'm being silenced. I mean, I have a right under the free speech to petition the court for redress of grievances and things of that nature. And if you look at the TV show Judge Judy, this is how she acts, Judge. Totally wrong. And she asked me, what did I want to do with the case? I said, I would like to challenge jurisdiction because I went to prison in 2002 for 15 years and 8 months. They had under the rule, it's, I believe, for misdemeanors 40-something days, for felonies is 6 months. So I request that the prosecutor prove its authority in bringing these charges so late. And I have been home 6.5 years, productive in the community, no problems. And I'm trying to do right, Judge. I made past mistakes when I was a young man. And I'm just being treated like I'm just a criminal. I'm supposed to be innocent until proven guilty, right? So I'm not trying to disrupt this court. I'm not trying to cause you guys hardships or anything, things of that nature. And my due process is being violated, Judge. That's all. I want to just get this case over, wouldn't be left alone. I'm a grandfather. I have children. And their DPD has retaliated against me, Judge. And I know this is a Detroit police court. And I would like an investigation as to things that's been going on by the prosecutor's office because Kim Worthy and her subordinates are retaliating against me. There's actual proof.
At its core, his argument was surprisingly simple and surprisingly flawed. He essentially told the court, yes, the prosecutor was doing their job and trying to send me back to prison. But I'm a grandfather, I have children, so you should dismiss this case. It's a classic sympathy play. But here's the problem. Judges don't hand out dismissals based on family status. Their job is to weigh facts, evidence, and the law, not personal appeals. Judge Martin is widely respected for her fairness, and she's not the type to hold a grudge over someone's criminal history. Her responsibility is justice, not sentiment. And while the human element matters in sentencing, it doesn't erase the legal process, something sovereign citizens often struggle to accept.
I don't know if you're familiar with Bill Proctor. He's representing me in this matter and another matter so far as investigations for years of, hardships and tyranny committed against me by the system here in Wayne County. So this is all I want, a fair shake judge, a judge who's going to give me due process and give me what I'm entitled to according to law. And that's it, sir.
Okay. Ms. Ritter, would you like to respond in any way?
Judge, the only response that people have is that this is a case from 2002. It's a misdemeanor assault and battery case. Judge, from my recollection of the prior hearing with Judge Bryant, I do believe, if I'm not mistaken, that it was an arraignment process. And as the court was trying to proceed with the process, I do remember Mr. McCreary interrupting the judge while she was trying to make the record. But the people have not gotten to the point where, because Mr. Carnell was disruptive during the proceedings, the people didn't get to the point where there was another pretrial date set where the people could actually see if we're able to move forward on this 2002 case, Judge.
I have a rebuttal.
Yes.
Okay, Judge, I would like you, if it's possible, I know you guys are on Zoom, so you should have access to recordings of these hearings and things of that nature. I believe that the prosecutor just fabricated facts to you because I was not rude to this lady. All I asked her is, she said, what do you want to be done with this case? I said, I would like to challenge jurisdiction. And Michigan and federal law requires once jurisdiction is challenged, it must be proven. How is it that the prosecutor knows statute of limitations? They're licensed. I'm not licensed. I've studied for years in prison. And they don't know that there's a statute of limitations. This is vindictive prosecution because of my complaints against Kim Worthy, Your Honor. And the record will reflect the evidence. And I object to her statements.
All right. Court having had a chance to hear the arguments of the moving party, as well as the arguments of the prosecutor. The moving party is asking for a recusal or to have Judge Bryant disqualified based on Michigan Canons 1 and 2, based on that she is biased, as well as is not allowing a person to be able to basically argue their case. The moving party is stating that he wants to challenge jurisdiction and that he was not allowed to do so. The prosecutor is stating that there was only a proceeding at an arraignment and that the prosecution hasn't even got to the point where they have established whether they want to move forward with the case, but that was not allowed to happen because in their view, there was disruption in the court and there was a break.
Theatrics aside, the real issue here is that the defendant's legal performance isn't addressing the core problem, the unpaid rent. Instead, he's leaning on identity claims and procedural challenges that have no legal standing in this context. It's the kind of approach that might sound clever in an echo chamber. But in a courtroom, it only tests the judge's patience. Watching the exchange almost feels like a game of chess where one player doesn't know the rules, and the other is simply waiting for the checkmate. The judge seems calm, almost amused. It's carefully letting the defendant talk himself into a corner before stepping in with the facts that matter.
The moving party is disputing that. He's saying that I could go to the video with tapes to dispute that. At this time, the court is not going to make a decision at this point. I am going to pull the tape, pull the transcript. I'm going to make a decision very quickly on this. I'm not going to let this continue. And even based on, the court does have an opinion probably on the likelihood of prosecution on a 21-year-old case. So we're going to come back on, we're going to come back on July 6th at 10 a.m. Please check your schedule, sir.
May I also, you say July 6th, sir?
Yeah.
Okay.
Yes.
May I
Next,
also, if I may, Judge,
check your schedule first. Check your schedule to see if are you available for that time.
I'm available. I'm stuck here on tether, sir. I'm available at any time you guys want me to.
Okay, all right. Well, put it on your schedule for 10 o'clock on July 6th.
Okay, can I say one more thing? If you look at Crampton versus Michigan Department of State 395, Michigan 347 at 351, it says the United States Supreme Court disqualified judges and decision makers without a showing of actual bias in situations where experience teaches that the probability of actual bias on the part of the judge or decision maker is too high to be constitutionally tolerable. And I'm not saying like trying to attack Judge Bryant or whatever else, but she has an attitude like Judge Judy. She just cuts you off. And I'm just like, so when she kept doing it, this is when I objected and asked her to recuse herself.
And sir, and again, as the chief judge, I don't have to have a showing of actual bias, but perceived bias, something in the fairness of justice. That is my.
Then comes the verdict, and with it, a new payment amount higher than the original rent. It's a practical outcome, but also a steep consequence for someone already behind. If he wasn't willing to pay $500 a month before, there's little chance $700 will suddenly appear. What's surprising is how quietly he accepts the decision. Many sovereign citizens react with loud protests or disruptive outbursts. But here, he simply listens and nods. Maybe it's resignation, or maybe he spent all his energy on the scripted speech. Either way, the result is the same. The court has spoken, and the law remains firmly in place. It's a reminder that no matter how polished a pseudo-legal script sounds, it can't override the basic obligations everyone is expected.